Let me hit the record so we can get into this. So we got some more YSL trial updates for y'all. It's breaking news. This is crazy. Right now, Damekion Garlington is taking a plea. He's going to take a non-negotiated Alfred plea. So we're going to get into the story right now. We've got it live streaming and see what Judge Whitaker has to say. You know what time it is. Shout out to Judge Whitaker. Let's get into it. Was not expecting this today. Here we go. I probably spelled this name wrong too. We'll get to see some old faces, some familiar. Oh, look at Miss Hilton. Miss Hilton's in there. You got a body. Who else is going to be up here? Let's skip ahead through some of this. And look, there she is, Judge Paige Reese Whitaker. Oh my goodness.
These niggas lacking.
You know what time it is. Damekion Garlington's walking in. We got his attorneys. I have no idea who they are. But shout out to them either way.
All right, we're on the record in case number 23 SC 183572. This is a sentencing hearing for Mr. Garlington, who entered a guilty plea to certain of the counts against him yesterday. Okay, and we're on hold. They need a Zoom link.
Oh, the nostalgia. How are y'all feeling?
We're on right now.
Who am I sending it to?
Miss Warlick. And I guess does this stay? All right. So, we ready? Okay. All right. So, is the state going to go first? And I don't know what the recommendations are at this point. So, if y'all could let me know that as well.
Yes, Your Honor. Good morning, Your Honor.
Good morning, Miss Hilton. She's back. It's not morning, though.
Yesterday, Mr. Johnson pled to count 1 of this indictment, which is conspiracy to commit the racketeering and corruption organization.
So they got another one for Rico. Dang.
Count 49, which is aggravated assault, but murder, reduced aggravated assault. Count 50, participation in street gang activity, and count 54, possession of firearm during the commission of felony. Those charges are total exposure of 85 years.
Right.
As you heard yesterday, Mr. Garlington is currently on probation. Indictment 15 SC 138894 for crimes associated with the April 28, 2015 drive-by shooting of Adele Avenue and Drew Drive. He received a total sentence of 15 years to serve 5 years in confinement. That probation ends on December 27, 2029. The state brings that up, Your Honor, because as a general condition of probation, Mr. Garlington was not to violate any criminal laws, and as a special condition of that probation, he was to have no direct or indirect contact with any YSL members, no contact with any gang members, and no gang-related social media.
All right, and is the state seeking to revoke that probation?
Not at this time, Your Honor. And while we're not here for a probation revocation matter, the state thought it was important for this sentencing court to be aware of what Mr. Garlington was required to do, because he has failed to comply with any of those conditions.
Oh, man.
Mr. Garlington chose to continue to associate with YSL gang members, to include Shannon Stillwell, Kenneth Copeland, Jeffrey Williams, Khalif Adams, Jaden Myrick, Quantavia Greer, and that's the name of few. He then engaged in a conspiracy to attack a rival gang member, Rashawn Bennett, who was
Shout out to Judge Whitaker.
That incident ultimately led to a retaliatory shooting that killed Christian McMiller and Darius Ford, and that murder led to another retaliatory shooting in which the state believes that Mr. Garlington was a part of, which was a retaliatory shooting that killed Mr. Shamel Drinks on March 14, 2022. After Mr. Drinks was murdered, it was Mr. Garlington on his social media post that said, "We got you boys." And this was only hours after the murder. And the state believes that was to indicate that he, along with Shannon Stillwell, avenged their friend's death. And even after that murder, it was Mr. Garlington talking with other gang members over the phone while certain individuals were in custody to get protection for fellow YSL gang member Miles Farley. It is the state deciding its recommendation, Your Honor. The state has taken into consideration a number of different factors. Mr. Garlington's previous criminal history, Mr. Garland's involvement with the YSL gang from 2015.
I cannot believe we're watching YSL stuff still. Wild.
We have certainly taken into consideration results of the previous trial that we had before the Honor. Given that, Your Honor, it is the state's recommendation
Y'all don't miss Hilton?
that for count 1, RICO, 20 years to serve in confinement. Count 42, participation in criminal street gang activity, which would be 20 years to serve, concurrent with count 1. Count 49, aggravated assault, 20 years to serve, consecutive, 20 years to serve concurrent with count 42 and count 41. Count 50, participation in criminal street gang activity, 20 years to serve consecutive to count 1, but on probation. Count 54, possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 50, for a total sentence of 45 years to serve, with 20 years in custody. As a special condition of that probation, Your Honor, he's had no contact with victims or co-defendants, no criminal street gang activity, no association with criminal street gang members, no firearms or gun replicas, no gang paraphernalia.
Hang on.
If he has not obtained his GED, be in school or gainfully employed.
Interesting.
And any Fourth Amendment waiver, including social media. The state did have, just as some evidence in sentencing, Your Honor, these are items that were presented during the first trial, but some of the social media posts that led
shout out to the cameraman.
Murder of Mr. Drinks, Your Honor. And I'm showing it to the counselor. And Your Honor, the first 3 states exhibit 1, 2, and 3 are pictures of Mr. Garlington with YSL associates Christian McMiller prior to his death, Your Honor. The third one is Mr. Garlington, you see him with his back, his head towards the camera with previous co-defendant Antonio Sumlin. State exhibit number 4 is a post by Mr. Shannon Stillwell, which was a few days before Chanel Drink's murder, which said ain't gonna be the only one crying. And then state exhibit 5 is the exhibit that I referenced earlier, which was done only hours after the murder of Chanel Drinks, in which Mr. Garlington posted, "We got y'all boys." Yeah.
You may. Any objection to those?
No objection. Dang.
And Your Honor, we do not have any victim impact statements for this sentencing hearing, and so with that concludes the statement.
All right.
I want to clarify, I did 45 years, served 20 years in confinement with a balance on probation.
Right.
Ooh,
Yeah, that's
that's
what I
a lot.
understood it to be. Thank you.
So, according to Thugger Daily and what we just heard, they're recommending 20 years to serve plus 25 years on probation. Ow!
So, we were grateful for the negotiations that we were able to get to, at least partially. We couldn't get there on the numbers, but I think we got there on the trial.
Good Lord.
The state's indicating what they took into consideration in making this offer. I guess kind of balancing what we were requesting. But I do want to just run through a little bit of Mr. Garlington's situation and juxtapose it to the other defendants.
Okay. We'll hear it.
As pertains to the charges here and in the indictment, I don't believe at any point anyone is alleging that he was a leader. And at some point in 2015,
No, Garlington is not out.
on probation, he did cooperate with law enforcement. He gave a statement. They were questioning him about 2 shootings. He thought that they were only asking him about 1, and he did admit to his involvement in that one. His original sentence, I believe, was 10 to 2, and then ultimately he was resentenced to 15 to 5 credit for time served. I do want to point out that that probation violation that led to his revocation wasn't for him committing a new offense.
She's talking so low. He has a probation violation.
Associated with
YSL.
a gang member.
Yeah.
I don't have the case off the top of my head, but the 2024 case, and this was concerning the overly broad terms pertaining to child molester sentence, and said that it's overly broad in that sentence do not have any contact indirect or direct with children, right? I don't know.
Yeah, I think it was more that the condition that said stay away from anywhere that a child might be was overbroad, but I know the case you're talking about.
Yeah, and so same situation here. I believe it might be different, but I want to highlight the most out of there that he was not engaged in committing a criminal offense. He wasn't subsequently charged for anything, and that revocation took place in 2020.
That's fair.
Down for any other incidents until 2022, and that's where I would like to direct the court.
Problem is, Judge Whitaker don't play. Y'all know she does not play. If they say don't be around anybody that's in YSL, don't be around anyone that's in YSL. Or you. So I don't know how gracious she's going to be here. We'll see.
2022 situation. Of course, here's an overview of the charges. Of course, we're aware of the RICO and what the overacts are. Most of the overacts concern pictures, posts, and conversations amongst friends.
That's true.
Then we turn to a jail incident. During the time of the jail incident, Mr. Garlington was out of custody. There was conversation between Mr. Myrick and Mr. Adams. We went through most of this yesterday, so on the Zoom.
Right.
But he didn't. What wasn't necessarily within the text message was there was a confirmation from him saying, "Oh gosh, did you guys get this done?" Or "Wow." There was no request from him to make it public. Throughout the course of this, we've heard that the gang members seek recognition and acknowledgement, and most of the time they post their wins and whatever's happening. There's no evidence of that, of him seeking to say, hey, post this, let them know that this happened, let them know that I was involved here. He's not bragging about it. There's no evidence of him taking credit for it. And there's no evidence that he paid for it. I think that the state's theory was that he was involved in some sort of payment for this incident to take place. And the evidence just doesn't support that. In fact, from the incident reports from the jail incident, it seemed like they had gotten into an argument, Mr. Myrick and Mr. Bennett, before this happened. Mr. Myrick had been wandering around for a while. I'm going to attach just a snippet of that. He'd been outside of, they were both in protected custody. He'd been outside the cell, and then at some point Mr. Bennett was let out. Mr. Bennett had time to do his jail, or his video visit in peace, and then some sort of argument ensued, and that's when they got into it.
I wonder what would happen if they had the sentencing and someone from YSL came to visit him or see him when he got out. Something he has no control over. I wonder if they could pick him up and lock him up then. Wouldn't that be wild? If they could come, that would be crazy.
As it pertains to what happened with Drew's case, I'm sure the court heard that. I just want to reiterate just this part.
I remember it.
Okay, no need to play it, Your Honor. But as it concerns Mr. Garlington, still we have no direct evidence of him being at the location. We don't have evidence of him being in the car, so DNA. Not that that's a big deal, because again, there was very little evidence found in the vehicle to begin with for anyone. There's no evidence that they had planned to do this. And the post that was made after, and I get what the state would like for Mr. Garlington's intent to be behind that post, but it had nothing to do with Mr. Links. I don't think We Got Y'all Boys is just like a general statement of support. They were going to the studio that day. I'm not sure what inside jokes they might have shared. But I just am hesitant without there being other evidence to infer nefarious intent to a post that's so general in that nature. Of course, the video that the court is aware of, it doesn't even support, even if there was a breach to put him in the car. It doesn't support. Now, there is enough circumstantial evidence placed in there. There is enough from their FBI situation with the cell phone, but even with that, there's conflicting evidence as to the cell phone tower. At some point, early March, there was a wiretap placed on Mr. Garlington's phone. The location data based upon his cell phone records. However, the wiretap is getting real-time locations of incidents. So this is what the FBI's looks like, and it's tracking him. The shooting takes place around 10 p.m. So they got his time located from 9:30 up to about 9:59 around here. What's interesting with the cell phone, the wiretap data, is that it shows that he's traveling up I-85, and where his cell phone picks up, it bounces from one tower to the next. Where it ends up is north and I think it's north and east. North of 20, east of 85. And so the incident location takes place west of 85 and south of 20. So then 9:48, it's only pinging up in that direction, which is more indicative of that he was traveling up 85 north separately, whatever, and then came down. And that is consistent with him being found on the highway, not necessarily in that location. That real-time data at no point puts in where the location of the incident was or the gas station. But again, circumstantial evidence can go either way. And so Mr. Garlington was willing to take the risk on that his Alfred plea, Your Honor. But I would like the court to consider the sentences of other individuals in this case based upon their leadership role, Mr. Garlington's lack of leadership role, his cooperation with lack of cooperation of enforcement. No evidence that he directly harmed anybody in this moment. For a lot of the previous defendants, there was no direct, or maybe there was not guilty enough presentation of evidence of direct harm, and his prior felony conviction. So what we would ask the court for is a global 40-10 and credit for time served with the balance suspended, and how we envision that would be a 20-5 on count 1, credit for time served, balance suspended.
20-5 on count 1.
32 10-year probation, consecutive, count 1, count 49, 20 years probation, concurrent with count 1.
How many?
20.
Okay, so that's 40.
Count 50, 10 years probation consecutive to count 42, and count 54, 5 years to serve, balance suspended. Credit for time served, balance suspended.
54.
So I think it's 45. Is it 45 plus 5? Who keeps farting? Y'all hear that? Let me see what Thugger Daly's saying. It's just hard to hear.
It looks to me like that adds
or
up
difficult to hear.
Let me read that back to you. What the recommendation is. Y'all are recommending
See if I can find
20
Thugger Daly.
serve 5 balance
Judge Whitaker's got us.
suspended on count 1, 10 probation consecutive to count 1 on 42, 20 probation concurrent with count 1 on 49, 10
that's
probation
30.
consecutive to 42.
So that's 40.
Is that what you said, or to 49 on count 50?
And then there should be another 5 somewhere. They're asking for 45 years to serve 5 commuted to time served and 5 years suspended.
And then on
So time
54,
served would be
5
30
to
years
serve
probation.
consecutive
Shout out to my dog,
40
Thugger Daly.
to 50 and suspended.
If he gets 30 years probation,
What
that'll be
is it? What are
amazing.
you
But that's still
suggesting?
crazy.
Trying to understand what your recommendation is.
I think the 5 was to serve concurrent and then balance.
54 has to be consecutive, right?
I'm sorry, it does have to be consecutive.
Fulton County, we
that would
got to
really
do
be
better with our
45,
chairs.
right?
Yeah, 45 to serve 5. And then that'll be suspended because he's already done time.
You serve. And you said 45 serve 10, but I don't see where that's coming from.
I'm sorry, it's 45 certified because I didn't give out suspended on that, the weapons charge.
All right. Anything else you want to present?
Yeah, sure. I know what to have his family members get an opportunity to speak with his, what we envisioned was not to just come in here and blindly ask the court to give him probation without a plan. I don't know what the court's take is on this, but a lot of this seems to be the situation where we have back and forth. Something happens to someone, then we have something happen to someone else. We're trying to minimize his involvement going forward to other criminal activity.
Well, there's never a need to engage in
Yes,
criminal.
correct.
I want to rephrase that.
I understand. What, or the perception, right? So what I've seen here is, without throwing anybody else under the bus, other individuals still carrying weapons under
Oh, y'all can't see.
presuming that would be the reason why, is that you feel that you are somewhat at risk, despite that being against
Judge Whitaker does not like that excuse. You're
The
what you're
law.
lawfully allowed to do.
you're telling that to the wrong judge, lady.
I don't even want the feeling of that, and I think the best way to alleviate that risk feeling is to remove Mr. Rowan from these situations and to have a plan going forward
Okay.
about what he's going to do with his life. He and I have spoken extensively about it.
That's good.
Of course, one cannot make
Get him out of Atlanta.
inside the jail to an extent. A lot of his plans involve leaving the state entirely, which I support. That would alleviate a lot of the risk.
Okay.
It's not just a risk for him, but as we've seen in the facts here, it becomes family members, other people, friends that become unintended targets of these various acts. On short notice, we weren't able to lock in a lot of provisions for what he could do and what we hope he's going to do. But I do want his family to at least discuss with you about the plans that they have, so that the court understands that we're not just saying, hey, just let him go. We'll hope for the best. No, we have something.
Okay. Have you discussed with the family what those plans are?
I have.
Okay. Well, why don't you let me know what they are?
So generally speaking, his aunt is a business owner. She owns a number of businesses.
Nice.
So she's able to employ him. It's like one is like a lawn care service. She's got several contracts for that.
Is this local?
Not local in Atlanta. I think it's Metro Atlanta. Is that correct? DeKalb.
Pretty local.
That's still local. Get out
What
of
other
get out of here.
ideas?
So that would just be the first one.
Yep.
Judge Whitaker does not want him here.
I would like for her to speak about who she reached out to out of state. So she's got other relatives out of state that she was able to speak to. I wasn't able to speak with them directly, so that's why she went to the court to allow her to communicate directly about what those plans are.
Okay.
Would you like me to go ahead on?
Not to just tell me what her idea is for his rehabilitation.
Oh, okay, he's got his aunt up here. Shout out to Auntie.
Good afternoon.
My name is Marquita Cook Johnson. I am Damekion's maternal aunt. I am a native of Atlanta. I'm a military veteran. I do own
Thank you for your service.
in DeKalb County. One is a salon wellness retreat, and the other is a boxing gym, which my partner and I own together. This was a very short notice. I do understand as far as my goal is to get him out of Atlanta as a whole. Prior to his arrest, I had taken him on his first out-of-town trip to get him acclimated to traveling and just seeing weapons outside of Atlanta. I was stationed on the West Coast in California. I have several connections there, and as well as Virginia, mostly states where military people reside. I have reached out to a few of my fellow shipmates who are now retired, like I am, that are in a position of mentorship. I feel like for Damekion's safety and as well as my family's safety, it is best for him to relocate as a whole, and also to have realistic expectations. I have in the past had custody of Damekion. He knows I run a very strict household, but even as an adult, at this point, he needs to have a curfew because outside is not the greatest place right now. So, under the terms of him being able to come for immediate employment. My partner is also law enforcement as well in Rockdale County. So, in order for him to come and gain employment with us, he will have very strict accommodations. And like I said, the long term is to get him relocated out of it.
All right, thank you.
Judge Whitaker isn't a fan of him
already served on this
sticking
case?
around family.
Your Honor, Mr. Garlington has been in since September 28th, 2022, which was 974 days.
All right, anything else from the defense?
Custodian will be able to correct, but I think it might have been May when he got arrested.
I checked Odyssey, and that was the date.
Ms. Shelley, can you let me know what you show for his time served so far?
As far as the jail
Pre-trial?
law, you said what now?
Pre-trial? Yeah, well, yeah, in jail.
I don't have access to the pre-trial
don't?
system, just regular felony.
Okay.
Things.
Well, darn. What do you show? I mean, there's an arrest date of May 11, 2022. Whether he was released and
There's
rearrested, I don't know.
Damekion.
Oh, okay. Yeah, well, that part I don't think would count in his favor. I don't really know how they. But it wasn't on this case.
What do y'all
If he
think
was
Judge Whitaker is going to do?
For some other case.
He was in custody on this case, even though he went to prison on the case. I'm not saying his prison time,
I
I'm
don't-
talking about when he was first arrested was May 11, 2022.
Okay, well-
Who's that speaking?
It's either 974 days or 974 days plus about 4 more months, right? All right. All right. Anything else from the defense?
All right, what's it going to be,
All right.
Judge Whitaker?
Any rebuttal, I guess, from this state, which I don't know if that's the thing, but anything else from the state?
No, Your Honor, I believe that you've heard a number of
The wiretap evidence, within the first trial, Your Honor, that we don't need to reiterate. It is the state's position that Mr. Garlington was given an opportunity to redeem himself when he was resentenced in 2020. And as opposed to working with his aunt or as opposed to leaving the state then, that's not what he did. He re-engaged in gang activity in which we have the text messages regarding the stabbing of Mr. Bennett. And while there might not have been payment, Mr. Adams, after the stabbing of Mr. Bennett, surely reached out to Mr. Garlington on multiple occasions to try to get payment for that particular incident, and either never transpired, but there was some expectation of payment for that act to be completed. Again, after the murder of Mr. Drinks, there was laughing about the murder on the wiretap. There was a concern about
Jamil Drink's
cleaning the
murder
vehicle.
still hasn't been solved. Great
and
job,
then that is
DA.
all from Mr. Garlington's mouth and words. There was concern that other co-defendants were going to tell, and how do we get that person not to speak? So Mr. Garlington unfortunately never learned his lesson the first time around. If he had, maybe we wouldn't have been here, and that's
Okay.
all.
Thank you. I'm going to take about a 10-minute recess, and then I'll be back with the sentence.
Oh, wow. Okay, so we're going to get into it. What is Judge Whitaker going to decide? We got to get Judge Whitaker on the channel before she goes to the Supreme Court, which I hope she gets it. There she is. She's back.
Can we get Mr. Garlington back out? Can the state provide what the statute for aggravated assault is on that lesser on 49? Thanks. 49, yeah. You have this. Okay. Yes, and they've null prossed 40, 43, and 50.
Okay, so it looks like he might get it. I heard null pros, so we'll have to see what happens. Looks like he might get a good deal.
All right, we're back on the record, and I have taken into consideration the state's recommendation, the defense recommendation, the evidence that's been presented. I also am obviously aware of the evidence that was presented in the other trial, and I have taken a look back at the sentences that this court imposed for co-defendants from the prior trial, including co-defendants who were charged with some of the counts that Mr. Garlington is currently charged with and has entered an Alfred guilty plea to. Also taken into consideration his prior record as well as the prior records in the other cases in which this court sentenced. Also, other than one of the sentences imposed by this court in the first trial, the sentences that were imposed were joint recommendations, and I've taken that into consideration as well. The sentence for count 1, which is the RICO count, is going to be 20 years to serve 5. The balance of 15 probated. Count 42, the sentence is 20 years, serve 5, balance probated, concurrent. The sentence on count 1 reduced, I'm sorry, not 1, count 49 reduced to aggravated assault under OCGA 16-5-21. Is that what you said, 21? Okay. Is 20 years to serve 5 with the balance probated, concurrent with the other sentences. And I'll note in that regard that one of the defendants charged with that set of crimes was found not guilty, and 2 others, the state decided to null pros the counts against them.
Yeah, thank you, Judge Whitaker.
And count 50, the sentence is 20 years, serve 5, balance probated, concurrent. And then the sentence for count 54 is going to be 5 years consecutive to count 50. And it can be suspended upon successful completion of probation. So that's essentially 20 years, 5 to serve with credit for time served, 15 years probated, followed by 5 to serve, which can be suspended and will be suspended as long as the probation is successfully completed.
Nice.
Special conditions of the probation: no contact with any of the victims in this entire indictment or with any of their family members.
That sounds like you got a good
deal.
deal.
No contact with any gang members from any gang whatsoever. No gang paraphernalia, no gang associations, no guns, no replicas of guns. You need to secure full-time employment within the first 6 months after you're released from probation. You need to sign a social media waiver and a 4th Amendment waiver. And that is going to mean that during the entirety of your probation,
you need to shut
law
the
enforcement
fuck up.
at any time they want to can look at your social media posts, can search your person, can search your home, can search your car with or without probable cause to ensure that you do not have any gang paraphernalia, any guns, any drugs, anything you are not supposed to have. You need to secure your GED, which I know you told me yesterday you were working on it and had gotten to parts of that already. Go ahead and get the rest of it within the first year of your probation. And I am going to require that you stay out of Fulton County for the entirety of your probation.
Good.
All right, that is the sentence of the court. I hope that, as I have said with the other defendants whom I've sentenced, that this has been an opportunity for you to realize that the direction that your life was going is not a good direction, and that you are determined at this point to turn your life around and make good decisions from here on out. Associate yourself only with people that are going to help you to stay on the straight and narrow. So you've got a little bit of time left to serve before you're released. I think a couple of years at least, but go ahead and do that. You can be working on your GED and on job skills while you're in prison. Good luck to you. And I hope not to ever see you again, because if you violate your probation, you're coming before me. So let's make that not be a thing. Okay. All right. Good luck to you.
There she is, man.
What?
Judge Whitaker is amazing. Oh my goodness.
That concludes
Judge
court for
Whitaker's
the day.
GOAT. That's it. Shout out to Judge Whitaker. Super fair. Doing the right thing. She's so good for the community, man. Getting these guys, helping them get back on the right track. And of course, the DA's office, they didn't have their case together. So there's nothing to show that Damekion Garlington had anything to do with the murder of Shamil Drinks or this RICO in general. But he is going to have to serve 2 more years. He's going to get 20 years probation. And I think this is totally and completely fair. He needs to stay out of Fulton County. He needs to get out of Atlanta. Just start over, man. What do y'all think about this? Shout out to Judge Whitaker. Wish her all the best. I'm sure this isn't going to be the last time we see her. Let me know what y'all think in the comments in the chat.